everybody to the HPMA Yorkshire and the Humber, and this is a webinar relating to the legal challenges in the People Plan. It's great to see so many of you here, and you're most welcome. I'll start with a few introductions. So I'm Jenny Ellen, I'm Director of Workforce at Leeds Community Healthcare Trust and the Leeds GP Confederation. And I have with me this morning Heather Bellis, who works for Hempsons Solicitors and is brilliant in terms of supporting the HPMA branch. So Heather, did you want to say good morning? I can see you on camera.
Yes, good morning everybody. It's lovely to see so many here, so hope you all enjoy this. So thank you.
Thank you, Heather. And I've also got Andrew Davison. Andrew, did you want to introduce yourself?
Yes, hello, Andrew Davison, National Head of Employment at Hempsons.
Brilliant, thank you. So if I could just mention a couple of things before I hand over to Andrew, who's going to lead this webinar for us. So we are recording today. I hope that is okay with people. It's important to let you know about that. We do have the facility to edit out questions or discussion if needed, but I think it's important that everyone knows it's being recorded. I'm going to let Andrew go through the slides, but there'll be plenty of time for questions and answers at the end. Please do use the chat function as we go through, and we'll also invite people to speak and ask questions as well. It's great if it can be interactive rather than you all listen to Andrew and I for the duration of the hour. As interesting as we are, Andrew, I think, you know, this is intended to be for others. Yeah, benefit.
So, yeah, I couldn't agree more.
So yeah, I think I'll hand over to Andrew, and welcome to the session. I hope you find it useful, and thank you, Andrew.
Thanks very much, Jenny. Thank you. So, as I said, my name is Andrew Davidson. I'm the National Head of Employment at Hempsons. And for those who've not come into contact with us, Hempsons is a law firm specialising in mostly in healthcare, certainly in NHS work. We work for hundreds of NHS organisations. And the reason I say that is because it gives us an insight in the employment team into the kind of issues that you face as NHS organisations. So the session is focused on legal challenges in the People Plan, and it would be safe to say that there are many challenges in the People Plan, and they're not all legal challenges. Some of them are just people challenges generally and workforce challenges. But we thought we would put together a sort of overview, I suppose, of the kind of main issues that we think NHS organisations will face in the implementation of the People Plan. So it's not intended to be a comprehensive overview by any stretch, because there are so many things in the People Plan that you'll all have to get to grips with in time. But it's intended to focus on the main thing. So if you look at the People Plan, if you look at the document itself, there are 6 chapters to it. I think broadly, from my point of view, if you look through it, it fits into 4 themes. There are 4 themes, I think. One is looking after people, which of course is a huge part of the People Plan. Belonging in the NHS, as it's described in the People Plan. So looking at things like inclusion, inequalities, diversity. Then new ways of working, implementation of more integrated care, for example. And then finally looking at recruitment and returning, growing, if you like, the NHS. So my focus is going to be on the key legal challenges that we think you're going to face in the time to come. So this is an overview of the session of the session itself. As Jenny said, there'll be plenty of time at the end for questions, hopefully some answers as well, but certainly questions. And if anybody has any particular comments or points that they've encountered in practice, or they have particular issues with, then we have plenty of time for that. We should run about an hour, so there or thereabouts. We're down for about an hour, 60 minutes. But as I say, there'll be plenty of time for questions at the end. So those are the things I want to cover. Looking first at systems working. One of the key themes, it seems to me, not just in the plan, but in the thinking in the NHS for the last, well, at least 5 or 6 years, has been around flexibility and looking at more flexibility for the provision of services. Looking at new roles and responsibilities. If you go back to the 5-year forward view, for example, there's a great emphasis upon new responsibilities, looking at a different specialist generalist mix. That's been a recurrent theme. If you look, for example, at the HEE document, Future Doctor, which published last year, that very much is focused on an educational offer for generalist training. So there's some themes there, and closer working. I mean, the white paper that's recently come out is all about closer working, it seems to me, and looking at how systems can work together across the NHS. So close working, not just within the NHS, but also across other sectors, so charities, local authorities, and so on. So that's just a sort of by way of background. It seems to me that the people plan is just another step on that path towards a more integrated system. I mean, of course, the NHS was set up deliberately to be separate in many respects, and ever since 1948, I think governments and those responsible for leadership in the NHS have kind of tried to bring it back together, and this is very much a theme in the people plan. So practically, what sort of challenges will you face when it comes to that kind of integration and working together, working more flexibly? Well, I think there's a few things that are obviously, to me anyway, obviously themes, things that you might face a challenge around. If you're trying to get people to work more closely together, there are many ways of doing that. There's things like the host employer model, for example, TUPE, which I'll talk about. But also in the short to medium term, maybe in some cases in the long term, but you might be looking at secondments. And I start with secondments because secondments from a legal perspective are in many respects the simplest way of moving people around the healthcare system and getting people into new responsibilities. And they're the simplest way in many respects because by definition they have to be voluntary. So people have to volunteer for secondments, they have to be agreeable to a secondment. And in practice, you can have a secondment arrangement in place very, very quickly. So I've been advising a client very recently about some shared services. And in the short term, it seems to me the easiest way, given that there is a great will within the workforce, is to use a series of secondments and then look at a longer term solution. There are two issues. So in terms of legal issues around secondments, there are two issues to look out for. The first is not common, but it is an issue, and that is who is the employee, who is the employer rather, in these circumstances. Because if you have an employee who is seconded from organisation A to organisation B, there is a risk, and it may be small in many cases, but there is a risk that if challenged, the employee would be considered to be an employee of employer B. So the person that they have been seconded, the organisation that they've been seconded to. The leading case on this is a case called Fitton against City of Edinburgh Council. And it's an unusual case in some respects. It's not your common law garden secondment. What happened in this case was Mrs. Fitton was seconded to a joint venture set up between the council and another organisation. And the secondment was originally for 12 months, but was expressed to be after that open-ended. And the reality was that Mrs. Fitton had, to all intents and purposes, become an employee of the joint venture organisation. And so when challenged, when she challenged it in the employment tribunal, they accepted that she'd become an employee of the organisation to which she'd been seconded. Now, that's not common. And in this case, one of the key features was this open-endedness of the secondment, the idea that there was not really a plan at all for somebody to return. But if you're setting up, integrated working, if you're setting up shared service arrangements and you're doing it via a secondment, you just need to be mindful that employee status may have transferred to the organisation that's accepting the employee as the seconder. So that's the first potential challenge. In terms of managing that challenge, you have to keep in mind that the tribunals will look at the reality of an arrangement. And so whatever you say in the contract, that's important, of course, but it's not the end of the consideration. The tribunals will look at the reality. And if you've got an employee who has been seconded to an organisation for a very long period of time and there's no obvious end point, there is at least a risk that the employee will have transferred their employment. So that's a risk, but it's generally an uncommon risk. A far more significant risk is a lack of clarity around liability and management responsibilities in a secondment arrangement. And if, as often happens, the arrangement is relatively informal, you can become a little bit unstuck around issues such as management of performance, management of sickness, management of disciplinary issues, unless you've got a clear line of responsibility and it's obvious who's responsible for the employee in those circumstances. So when we put together secondment agreements for clients, almost the most important thing always is who is responsible for what, and if there are employment tribunal claims or if there are disputes, who's going to be liable for those disputes and those claims. So those are two things to keep in mind around secondments. But as I say, secondments, because of their very nature, are generally less problematic than some other issues around flexible working and working together. More problematic, as most of you will probably have experienced in practice, is TUPE, the Transfer of Undertakings in brackets Protection of Employment close brackets Regulations 2006, otherwise known as TUPE. I'm sure most people on the call will at least have come across TUPE in some form, and this isn't a webinar on TUPE. That would take a long time. So I'm not going to talk about TUPE in great detail, but a few points really specifically around integrated working closely together. The first is that you can have what I would describe as an unintentional TUPE transfer. If you have people working in a system and responsibilities are shifting, responsibility for a service is shifting and so on, you can quite frequently get to a point where there might have been a TUPE transfer but nobody's realised. So it can be an unintentional thing, and it's not something that you choose. Very often I hear clients talking about, oh, we've decided to do a TUPE transfer, we've decided that TUPE will apply, and that isn't the case. TUPE is a matter of fact and law, and it's something that, if challenged, will be determined by the tribunal. So you don't have any choice about whether TUPE applies. If you're transferring a service, then it would otherwise apply. So that's something that's important. And there are a number of cases where there have been TUPE transfers without anybody necessarily realizing that was what was happening. So if you are moving towards that more integrated system, it's worth keeping in mind there might be a TUPE transfer at some point. And if there is a TUPE transfer, then there are some obvious consequences. There is an obligation to inform appropriate representatives about a transfer. There's also an obligation to consult appropriate representatives. In your case, as NHS organisations, nearly always that's trade unions, of course. But there is that obligation, and you need to ensure that that's been put in place. There's often a contentious issue about who it is that transfers. If you've got a shared service, do all the employees transfer? How do you determine that, and so on? And again, that could be the subject of another separate webinar on who transfers under TUPE. It's a complicated issue at times, but it is a consideration, so it's something that you need to have in your mind. The other two issues that arise are timing. So at the end of the day, you've got to make a decision, you've got to have a view rather about when the transfer will take effect, and that isn't always obvious. I've had a question, for example, about setting up a shadow host-employer arrangement, and if you set up a shadow and if the responsibilities have transferred, there is at least a risk that there has been a transfer, TUPE transfer, or there will be very shortly. And then finally, the real challenge when it comes to shared services, it seems to me, and integration is if you have had a TUPE transfer, making changes to terms and conditions, because it's notoriously difficult to do that in a lawful manner. And I don't want to say huge amounts about that, except that it's not always an easy process, because employees are protected against two things under TUPE. One is a dismissal, if it's connected with the transfer, and the other is any changes to terms and conditions, because employees transfer across with their existing terms and conditions, and it's notoriously difficult to make changes to that. And I say that in the context of shared services, because I think very often people think if you get everybody under one roof, if you get everybody employed by the same organisation, it's very easy to then make changes, terms and conditions, and it really isn't. So that's TUPE. I think there's some questions. I'll just have a quick look to one side. Is there a time frame when TUPE becomes automatic? Not quite sure what that means, but in terms of whether it happens, there is no time frame. No, I mean, it's TUPE is a matter of fact and law, and so it doesn't really make any difference in terms of the timing. What makes a difference is whether or not there has been the circumstances that would set down for a transfer. So maybe we'll come back to that question in a bit, and we can clarify exactly what that means. But let's just go back to the slides for a second. So that's TUPE, and you may have questions about TUPE. That's absolutely fine. We can pick them up at the end. The other obvious thing, it seems to me, with integration and shared services working together is the potential for changing terms and conditions. And this can be a constant challenge. There are many ways of doing it. You can see on the slide various options available to you. Again, this could be a session. We are doing a session on contracts, which I'll talk about at the end, but there is a whole webinar on changing terms and conditions, so I haven't got time to talk about that in great detail. But just to make the point that there are various options ranging from individual agreement, which is the best. If people agree to changes in their terms and conditions, that's definitely the best thing for them. So it's easiest if people just agree. Then after that, in terms of ease, you've got collective agreement with trade unions, which is great. Then you've got, if you can do that, then you've got implied variation, where you impose it in effect, almost impose it. And then finally, dismissal and re-engagement. The only thing I'd say is that dismissal and re-engagement is by far and away the most certain way of changing terms and conditions. But it also, of course, gives rise, because you are dismissing, it gives rise to the potential for unfair dismissal claims and general sort of unease, I suppose is the word, in the workforce. So it's not an easy thing to do, but certainly from a legal perspective, it's the cleanest, because you're less likely to face future challenges if you do it that way. There might be questions about changing terms and conditions, but we'll come back to that at the end. Okay, so that was really all about, I suppose, systems working, ways of challenges that you might face if you're moving towards a more shared service arrangement, a more integrated arrangement. The second theme I wanted to look at was flexible and remote working, which is a real feature of the People Plan. One of the goals, for example, is all advertisements will be flexible by default from January 2021, which the astute amongst you will have realised has passed. That's the intention, that was the plan. And there is a theme of flexibility running through the People Plan. So flexibility, for example, for junior doctors in their training. It's important to remember that there is, of course, a statutory right to request flexible working for those employees who have 26 weeks service, but it's relatively limited. And so flexibility for employees who make a formal statutory request can only relate to the hours, the times, and the place in which they work. So it's quite a limited statutory right, but it is a statutory right. In terms of requests, then, I mean, both under the statutory regime and more generally, it's important, of course, that any options are discussed, any alternative options are proposed, if there are alternatives that you can come up with as an employer. Because that's what a good employer would do, and that's the theme of the People Plan. But also from a lawyer's point of view, if you reject a request for flexible working, there is the risk of certain types of claim. And broadly, that falls into two categories, potential risk. One is indirect discrimination, the idea that if you say no to people that have certain protected characteristics, that might have a disproportionate impact. The obvious example of that would be if a woman makes a request for flexible working in whatever form. As a general observation, women still have the primary responsibility for childcare. And so you could argue, and people have successfully argued frequently, that it is indirectly discriminatory to have a rule against flexible working or to have a resistance to flexible working, because it has a disproportionate impact upon women. I mean, equally, you can say that in relation to disability, potentially, you could say that it has a disproportionate impact if you're not flexible on people with a disability, depending upon the condition, and also religious belief, because again, for example, if you have a day of religious observance and you don't want to work on that day, having a rule that you work a 7-day week or whatever it happens to be is going to have a disproportionate impact upon you. Now, the thing about indirect discrimination is it's always open to justification. And so you may be able to say as an employer, We can't be as flexible as we might want to be, unfortunately, because we have service provision needs or whatever it happens to be. So it is potentially defendable, but it is a risk. And then also a risk, although I think generally in practice less of a risk, is a constructive dismissal claim. The employee could say that the way in which you've considered my request for flexible working is so unreasonable that I need to resign and claim constructive dismissal. So two potential risks around flexible working, and then of course you've got the non-legal risks if you refuse what's a reasonable request when it comes to remote working or flexible working. One key theme of the People Plan, so the third part of this webinar, is around what I would describe as eliminating discrimination, promoting diversity and inclusion. And I just wanted to make a few comments on that because it's an area, of course, that the NHS take very seriously, and rightly so. There are some potential challenges around that, and the obvious one, it seems to me, is around the balancing the requirement under the public sector equality duty with the need to avoid any positive discrimination, because positive discrimination is unlawful. So it's about getting that balance right and looking at whether or not you as an organisation are doing something which is considered positive action, which can be lawful, or whether it's positive discrimination, which is unlawful under the Equality Act. I just want to talk a little bit about that and how that works in practice. I mean, one of the things that we might get onto in the question and answers is that before I look at the public sector equality duty, if you look at the People Plan, there is a discussion, very brief discussion, but a discussion about things like the disciplinary gap, for example, which is the likelihood of people from certain ethnic backgrounds going into a formal disciplinary process and the seemingly disproportionate impact that has on certain groups. There are some ambitious plans. So, for example, in the People Plan, it says by the end of 2020, we expect 51% of organisations to have eliminated the gap in the relative likelihood of entry into the disciplinary process. I don't know, some of you might know the answer to this. I don't know whether that's been assessed in any way. I suspect that the 51% of organisations is a very ambitious project, given what the statistics were showing before, but clearly there is a direction of travel to try and reduce that inequality. So just coming back then to the what's lawful and what's not lawful under the Equality Act, I should just say that the public sector equality duty, for those who are not familiar with it, is a general duty to avoid discrimination and to promote equality. So positive action, as I say, can be lawful, and this applies. There's a general duty, or general possibility rather, of positive action where there are one of three circumstances in place. First of all, where there's a disadvantage connected to a protected characteristic, so that could be race, disability, sex, and so on. Secondly, where people with a protected characteristic have different needs, so you may have to make adjustments for different needs of different groups, of course. Or finally, participation in an activity by persons who share a protected characteristic is disproportionately low. And again, this is a relevant consideration for the People Plan, because if you have people in leadership roles, for example, where you don't have a representative sample, put it that way, in leadership roles, then you could argue potentially that participation in those leadership roles is low amongst people of a certain protected characteristic. So those are the three circumstances. There may be some overlap, of course, but those are the three circumstances in which the positive action provisions could apply. And then if they do apply, employers can lawfully take any action which is a proportionate means of achieving the aim of enabling or encouraging persons who share that characteristic to overcome or minimize the disadvantage, meet the need. So remember, we talked about the potential for people with protected characteristics having different needs. So the action you can take is to meet those needs, which it makes sense. And then finally, enabling or encouraging people who share the protected characteristic to participate in that activity where they are disproportionately lowly represented. So that's the general duty. Just prior, maybe move on to recruitment. That's the general duty, and that allows organisations in the public sector to lawfully take action which might appear to be positively discriminatory, but it's called positive action. I'll talk about some of the practical issues right at the end. So the specific provisions. There are specific provisions relating to recruitment. Some of you may have come across this particular provision, but this applies where there is a disadvantage connected to a protected characteristic, or there is low participation by people of a protected characteristic. And in those circumstances, when it comes to recruiting, you can treat the person with the protected characteristic more favourably than another person. However, they must be as qualified as the second person. And so in effect, this is kind of a tiebreaker. If you've got two candidates who are both as qualified as each other for a role, you can lawfully give the role or the promotion to the person with a protected characteristic, as long as you've got one of those two circumstances. In other words, as long as there's low participation by people with that protected characteristic, or they have an identifiable disadvantage. So this is in effect, as I say, like a tiebreaker. You can only really do it where you've got people that are as qualified. What you can't do is if you've got people that score lower in an interview, for example, you can't take the view that you will promote them regardless because of a protected characteristic. Can't do that. That would be positive discrimination rather than positive action. So one of the practical issues that we've been asked as a firm a few times is about targets and having targets for participation, because the People Plan refers to agreeing diversity targets to reflect communities that the healthcare organisations operate in. And they are, in effect, so targets are aspirational, it seems to me, obviously. They're not quotas. Quotas are very likely to be unlawful. So if you say we insist on a certain proportion of our board, for example, coming from a certain community or having a certain protected characteristic, that's going to create problems for you without question, seems to me, because that is positive discrimination, in my view, not positive action. But if you are setting goals and you're setting targets, and you're using the positive action provisions, as I've talked about before, because there is a disproportionately low participation in certain areas, then I don't think that's going to be a problem. It's unlikely that's going to be unlawful. But it is something to watch out for, because I think the difference sometimes between targets and quotas can be slim. So it's being careful about how you reflect that in your organisation to make sure you don't fall foul of those provisions. I mentioned earlier on the idea of the disciplinary gap with certain protected characteristics, certain groups. It is important that that is addressed in some way. I don't think there's any easy answer to that. I'd be interested to hear any comments on that when we have our Q&A at the end. I don't think there's an easy answer. I think that part of the answer, at least, comes back to the Baroness Harding guidance that came out in May 2019, or rather the principles in that guidance, around things like making sure that the methodology for taking employee relations issues forward is consistent, making sure the principle of plurality applies. In other words, you don't just have one person making a decision about employee relations issues and disciplinary issues. You have that as an advisory thing. And then finally, the board having an overview and watching how things are progressing or otherwise when it comes to disciplinary gaps. So I don't think there's any easy answers to it, but certainly it's something that organisations are going to have to address. I'm just going to move that so the sunlight doesn't reflect too much on me. Okay. And then the next part is a really significant practical issue, which is around health and well-being, and particularly sickness absence management. The provision, or rather the quote in the People Plan, is that employers should identify and proactively support staff when they go off sick and support their return to work. I think it would be very difficult to disagree with that. Of course, that's what NHS organisations do on a day-to-day basis. There are some, I mean, they're not very specific, I have to say, in the People Plan, but there are some themes in the People Plan that I think will change how we view sickness absence in the NHS to an extent. There is a commitment to improved occupational health support. That is a theme that I think is very welcome for most NHS organisations. It's intended to set up some pilot groups where occupational health are more involved in things like resilience and mental health and so on. Crucial to all of this in terms of management of sickness absence, some basic issues really for you to be reminded of, but medical evidence, we see very often decisions being taken without up-to-date medical evidence, and that exposes NHS organisations, definitely. Failure to consult, keeping the employee involved in the process, failure to look at alternatives, failure to make adjustments. These are the sorts of things that often organisations can fall foul of. So although most of it's pretty obvious, these are the sorts of things that you should be looking at as an NHS organisation to ensure that you're dealing with sickness in a consistent and fair manner. There's also a focus on mental health in the people plan, and again, this is a whole separate session on mental health that we could do about the legalities of managing mental health issues in the workplace. So I can't say too much about that because we don't have time, but just want to make a few observations, I suppose, from our experience. The first is that there's nothing that's inherently different about mental health and physical health, in the sense that your procedures, your sickness absence procedures, will apply equally to mental health issues. But obviously, it seems to me there is a requirement, and this is reflected in some of the cases, to have a greater level of sensitivity. You need to consider the origin, what's going on with the individual employee. You need to make sure that you have up-to-date medical information. Particularly, one of the issues that comes out of the cases, and there's a good case called Dixon, is very often with mental health conditions, there is an overlap between mental health conditions and physical conditions, and there is a need to understand what the cause of a particular conduct issue is. So in the case of Dixon, for example, it was an employee who had been subjected to disciplinary procedures on the basis of looking at, it was a council employee who was looking at porn in the workplace. And his defense to that was that he was diabetic, and that he'd had a particular episode which had led him to behave in a way that was uncharacteristic. Now, the reason that case was interesting is because the employer didn't investigate that physical cause of the misconduct and treated it purely as an issue of psychological issue. And the tribunal concluded that that was an unfair process. So you've always got to look at the cause of conduct, whether that's mental health, whether it's a physical factor. And then finally, when it comes to mental health issues, look at mitigation, look at the factors, take health issues into account. Doesn't mean that you're not necessarily going to dismiss or take disciplinary action if there is an underlying cause, but it is important that you've understood what the mitigating factors might be. There's also a discussion in the people plan about bullying and harassment. I don't want to say huge amounts about that, because I think you as HR people in the NHS already will have a great experience of managing these sorts of things. Just want to say a few things from a legal perspective. The first is something which some of you may already know, but there isn't really a definition of bullying in the employment law statutes. The closest we get to it is the ACAS Bullying and Harassment at Work Guide for Managers, which talks about, as you can see from that slide, offensive, etc. behaviour and abuse or misuse of power through means that undermine, humiliate, denigrate, or injure the recipient. I would say about that the definition might suggest that it's always, or at least frequently, about power relationship. It's not impossible, of course, for somebody who is more powerful, potentially objectively, to be bullied by somebody else. We do see, not uncommonly, grievances put in by managers about people that they manage. It's not uncommon, and it seems to me potentially certainly possible that bullying could go the other way. But generally there is, I suppose, a power relationship there. So there's no statutory definition, and being bullied in itself in isolation doesn't necessarily give rise to a claim. The potential liability really arising from bullying in the workplace is either in relation to discrimination, if it's on the basis of a protected characteristic, or where somebody resigns in response to it and claims constructive dismissal. But there isn't quite the same regulatory legislative framework for bullying as there is for other types of behaviour. And if you contrast that, for example, with harassment, which is very similar, and that's why we put bullying and harassment together very often in policies and discussions. If you look at harassment, although employees frequently talk about being harassed, there is a specific legal definition of harassment, and it must relate to a protected characteristic. So as you can see there, it's unwanted conduct related to a relevant protected characteristic, which has either the purpose or the effect of violating an individual's dignity, and so on, or creating that environment. So the important thing here is it's not always deliberate. Somebody can be harassed by another person if that's the effect it has, regardless of whether or not that was the purpose of the individual who's subjecting them to that treatment. So, I mean, in terms of practical stuff, the Baroness Harding recommendations will probably, for most of you, have led to a review of your internal employee relations policies, particularly disciplinary and grievance procedures. And that will also include, I'm sure, looking at whether or not you're protecting your staff sufficiently from bullying and harassment. And then finally, just want to say a little bit about recruitment, because if you go back to the beginning of this session, I talked about growing the NHS, and there are two parts to that. One is recruitment, which we've briefly touched upon, but also retire and return, which seems to be a common theme and can be problematic. There's no doubt about that. The key thing is having very clear policies and procedures in place, ensuring, particularly, of course, for doctors, that there is a very clear job plan. Looking at the justification for retire and return, it's not an entitlement. People are not entitled to return. They're entitled to retire, but they're not entitled to return. And so you should have that recognition that there's not an entitlement and that there needs to be some justification for the return. Why are we doing this in this way? Are there other options? And how are we going to do it? Very often, retire and return is on a fixed term basis. That in principle could be discriminatory. You could argue that it's discriminatory, indirectly discriminatory against older people, because of course retire and return generally is used by people that of course are retiring, which means they are generally older. And so potentially if you have a policy of saying it's only on the basis of a fixed term, that could be discriminatory, but you may have some justification for that depending upon the organisational need. And then finally, in terms of recruitment volunteers, there is a brief reference, and it is only brief, in the people plan to volunteers trying to use the services and the skills of volunteers. The only thing that I would say that's important from an NHS organisation point of view is making sure that there is a very clear line between those that are volunteering and those that are workers or those that are employees. For those of you who've read the news in the last few days, you'll see there's a case in the Court of Appeal about Uber, and that, although not relevant to these particular issues as such, it does show the way in which the courts are prepared to interpret employee status and look at employee status. And the potential risk around volunteers is that without you being aware of it, they've moved from being a volunteer into becoming either a worker or an employee. So that's really the only risk when it comes to volunteers. And that brings me to the end of the formal presentation. So, do we have any questions? Now, the way in which I propose to do this is, if you want to put your questions in the chat, that's great. Now, there's a couple of questions there, I think. Equally, if you want to put your hand up, that's also great. If you're on telephone, that's not going to be so easy. And so if you need to unmute yourself to ask a question, that's fine. But we do have about 70 people on the call, on the session. So if we all unmute ourselves at once, it may be too chaotic. But let's play it that way. There is one question. Whilst people are thinking about their questions or observations, there is one question in the chat, which says, following the white paper which calls for new ICS organisations from the 1st of April 2022, we will lift and shift staff. However, it seems people who are VSM do not have the same protection. Is that lawful? Is Penny still with us? If you are, do you want to unmute yourself and then we can?
Yes, hello, I'm here.
Hi there. Yes. Sorry,
Yes.
just to clarify a little bit, just understanding your point in terms of the lift and shift. So what's your, well, maybe just expand a little bit on that question. So in terms of protection for VSM, why do you say they're not protected in the same way?
Okay, so I don't know where I've read it, but I've seen it in some
Yep.
document recently.
Yeah.
So
okay.
just thinking about the fact that my 3 CCGs are going out to market now for the creation of a single management team.
Yeah. Yeah.
If what I've read is accurate, then in effect we will be recruiting them later this year, and yet they won't have the TUPE across to the new organisation if what I've read is right, whereas we will be TUPEing everybody else.
I don't know what basis. I mean, that may well be the intention. I don't really see straight away what the basis of that would be, because if you are cheaping other staff, the fact that somebody's on a VSM contract doesn't necessarily mean they wouldn't transfer across. It may be, the point may be, I don't know, but the point may be, and this has been an argument in the cases for many years, the point may be that the staff in those positions are not actually providing the service in any way. They are sort of managing the service, and therefore they're not assigned to that particular service that transfers. That might be the argument. I don't know. I'm not familiar with that comment, but it could be that. And there is a line of cases that say, well, there's a line of cases that kind of say both things, which is unhelpful. But there is at least an argument that if you are, so for example, if I'm managing a service, I'm not providing the service, I'm managing the service. Equally, if I'm providing a financial function for a service, I'm not actually providing the service. And TUPE is all about the transfer of services. Mm-hmm. Now, I've got my own view in this, and I think it's supported by some of the cases, is that that's fine analysis. I understand the analysis. If you're not directly involved in providing the service, you may not transfer with that service. But in a way, I think it sort of dodges the point, which is you are still providing a service. If I'm a finance director managing several different organizations, for example, I'm still providing a service which goes somewhere, which is the financial service. It may not be the frontline service, but it's still a service that might transfer. So in answer to your question, if the position is people don't transfer because they're VSM, I think that's wrong. Right. If the position is people in VSM positions may not transfer because they're not mainly providing the service, then that is an argument. Absolutely, I can see the argument that might be made. But the idea that sort of VSM contracts do not transfer in some magical way is wrong. Must be wrong. It's all about what they're doing and whether or not they're assigned to a particular service that transfers. Does that make sense?
Yes, it does. Thank you. I shall go back to the source where I read it.
Yeah,
and if you challenge.
Absolutely, and if you want to come back to me, you're very welcome to do that. My contact details at the end. If you've got any follow-up you want to come back to me on, you're very welcome to do that. I've not seen that, but I can only imagine that might be the argument, that somehow those in those positions, because of the nature of VSM contracts, they might be in a different position, I suppose. But I'm guessing what the argument might be.
Okay, yep. Thank you very much.
It's never good when lawyers guess. Okay, do we have any more questions? There was a question about timeframes, which I have to confess I wasn't entirely sure I understood. But if you want to follow up on that, if there's anybody that.
Can you hear me?
I can hear you. Yeah, who's that?
That was me. I'm Alexa. And
hi there, Alexa.
The question was, so if you'd mentioned that it's quite interesting that TUPE can be unintentional.
Yeah.
And we're doing lots of secondments, for examples, these can be open-ended.
Yeah.
And that's a risk if it's open-ended from a legal perspective that TUPE can apply. Have I understood that right?
There's two separate points. In terms of an open-ended secondment, there's a risk that the employee may have become the employee of the organisation that's seconding, not under TUPE necessarily.
And how long does that? My question is, so would that be? Let's say they've been seconded for 2 years, and actually that contract has been extended for another 2 years.
Yeah.
That would be 4 years. Would that mean that they are employed? They're an employee of the new organisation, or
not necessarily? So this is a typical lawyer's answer, isn't it? But it's true. It's unusual. Work on this basis. It's unusual in those sort of circumstances that the employee will have become an employee of the other organisation. That's unusual, but it's not impossible. And so the things that you would look at are, for example, length of time. That certainly is a factor. So 4 years is quite a lengthy secondment. And if it's open-ended, if you keep extending and extending and extending, then you may expose yourself to that risk. But you also look at what's intended afterwards. So I can imagine a situation, for example, where you say, we're going to second you for 2 years, and somebody does the secondment, and then there's a really good reason why you're going to extend it for another 2 years, but you intend always that the employee will come back into their substantive role. If that was the case, then I don't think there's much of a risk that they've transferred across, because the intention is always that they'll come back. If you look at that case that I mentioned, the Fitton case, there was absolutely no intention of her ever going back to the council, ever. Just wasn't going to happen. And so you have to look at the reality. It's not always just the contractual arrangements. I mean, I would start to get nervous if it's a 4-year secondment. if I'm honest.
Okay.
But I don't. It's
Yeah.
not a guaranteed. It's not a guaranteed they've moved across. I just start to think, why is it a 4 years comment? Why isn't it? Why aren't we bringing it to an end? What's our intention at the end? Does that make sense?
It does. I've just got one more
Sure.
clarity, if that's okay. So we, in our organisation, we do quite a lot of partnership working.
Yep.
So we will often have teams where another trust will be working in the same building as social care, and they will all have the same referral route for patients, and they will be coming into our staff. So a member of our trust may be working on a site that's actually owned by a different trust.
Yep.
They get the referrals for the patients by that other trust, and the other trust is then paying us for that service. And that could be that can go on for years and years, and I don't know whether or not that would be that they should TUPE to that other trust. If that makes sense.
Yeah, it makes sense. Yeah, absolutely. Well, I think the key thing to keep in mind is who's responsible for the service and who's providing the service, because and that can be difficult. I mean, it can be a difficult question. It's not always straightforward. But if again, you'd have to unpick the history of it. But if you've got a position where a new organization has become responsible for the service and it's then being done by your staff, there's definitely a risk that there was a TUPE transfer. But it happened, if it happened at all, it happened when the responsibility for the service transferred. And so if you are, so I don't know what the arrangements are, but if there's, for example, like an SLA or something in place, that may be enough to say, well, actually, the responsibility for the service hasn't really changed. But that's the key thing. It's about who's providing that service. But your example is a good one, because very often, and we'll see this increasingly, you get lots of groups of staff who are working very closely together, and who's responsible for which part of the service can often be quite confused. And that's exactly where you might get this sort of unintentional TUPE, where there's been a change in effect, there's been a change in who's providing the service, which organization that is. And yeah, absolutely, you could get to a point where an employee challenges.
Yeah, it causes lots of issues, because we've done our job evaluation as well within our organisation, and we've banded these jobs at a band 4 level, whereas actually the other trust has banded them at a band 5.
Sure.
So it is difficult, because actually working together in the future, do we then upgrade hours, which means that the people that are in post haven't got the qualifications to be a band 5, or it's just a bit messy at the moment, I think.
Well, and I think your example is a good one, because it's exactly that kind of slightly messy, slightly unclear situation that I think most NHS organisations are in or going to go into, because you are going to work far more closely together, which obviously is desirable, but it also means you're popping up with all these sorts of new queries about whether or not there's a TUPE transfer. I mean, the other thing which I should have said probably about TUPE is that sometimes it makes no difference, as in, if the staff are happy where they are and they don't challenge, then it never comes unwound. So I can think of lots of examples where I've looked at, I've advised clients that yes, there probably was a TUPE 2 years ago, 3 years ago, 4 years ago, but it only becomes an issue if it's challenged. So it's only an issue for staff if somebody brings an employment tribunal claim, because ultimately the only person that can determine whether there was a transfer is the tribunal. That's it. There isn't like, with HMRC, where you can go off and get a view from them. There isn't such a thing. It doesn't exist. So if things have kind of settled down, very often my advice to clients is, well, if it's not, if everybody's working according to, the way they want to work, then it may not create you a problem, as long as there's a theoretical risk. Okay, there's a few more. So I hope that answered your question to an extent.
That's great, thank you.
Okay, there's no easy answer to those questions, I have to say. There's a few questions in the chat box, which I'm going to have a look at now. There's a question about danger that volunteers could be considered workers or employees. Expanding on this and giving an example. Yeah, so there is the line between volunteer and at least worker. So there are several categories of employee status. You've got employees, of course, who have the full protection. You've got workers who have some protection, so they have annual leave, for example, and sick pay and so on. And then you've got volunteers, and sometimes that line between volunteers and workers, at least, can be a bit blurred. I think the key thing to keep in mind is that volunteers have to be, it's a really obvious thing to say, but they have to be entirely voluntary. There is no requirement on them at all. And so what tends to happen, to talk about examples, what tends to happen where you have potential risk is somebody that volunteers on a very regular basis, does the same thing, comes in, does something productive for the organization, maybe receives some sort of remuneration. If you're paying for expenses, that's not a problem. So if you pay their bus fare or you pay their whatever it is to get in, that isn't an issue. But when you start paying them a little bit of extra money or something along those lines, and there's a regularity, then I would start to get nervous. I think if you want to be very cautious, you'd have a volunteer agreement which says very clearly, we don't expect you to come in, this is entirely voluntary, that's the whole point. And you keep an eye on that, because you don't want to get to the position where potentially you've got somebody who might be a worker or an employee. So I think most NHS organisations are pretty good at keeping the two quite separate, in my experience. But you might get to the point where somebody's doing it on such a regular basis, they could argue that they're really just doing you a service and they're not being paid for it. So that's really where the line is, it seems to me. And there's a question about shielding staff. So this is a good question. With shielding staff who refuse to have the vaccine either through choice or for health reasons, I assume at some point we would need to consider redeployment, and then if unsuccessful, could dismiss on health grounds. This is a really, yes, it's a good question, and it's a really controversial and contentious area, isn't it? Yeah, ultimately, all of this is the same as it was for anything else, and that sounds like a slightly philosophical existential point, but nothing really has changed in terms of your basis for dismissal. And so if you have somebody who is shielding, they can't come back in for that reason, and they refuse to take the vaccine for whatever reason, ultimately you as an employer have the option, the potential, to say we cannot consider this employee, we can't continue this employment for any longer, we have to move towards a dismissal. And that's always the case. You may have a reason for dismissal. Now, whether it's health grounds or whether it's some other substantial reason, which is another potentially lawful reason for dismissal, will depend on the particular case. So it's difficult to deal with, obviously, because of the current pandemic. It's difficult to deal with because of the very clear advice, for example, not to treat COVID-related absence as sickness absence for pay purposes. All of that makes life a little bit harder, but actually, fundamentally, you're still in the same position. When it comes to an employment tribunal, the question is still the same. Did you have a fair basis for the dismissal? Did you have a fair reason? And did you follow a fair procedure? Now, you mentioned redeployment, and absolutely that's something that you'd have to consider. Was there an alternative to dismissal? But if you get to a point where somebody is not coming in for the foreseeable future, so you've got a substantive reason there, and you've looked at all these alternatives, there will come a point, absolutely, that you can fairly dismiss that employee. And I think increasingly NHS organisations are getting to that position with some people. And there's no question that no matter what is being said from the centre, the reality is the statutory position is still the same. You have to say, is there a substantive reason? Do we have a substantive reason, health or some other substantial reason? And have we followed a fair procedure? If you do both those things, in principle, it can be a fair dismissal. I don't think we've got any more questions in the chat box. Jenny?
Could I just come in there, Andrew? So I think the difficulty with the vaccine question, as you just alluded to, is probably nobody wants to go first. It is a very controversial area. I was just interested in whether you'd offer the same advice in terms of staff testing, because I think that's also something that organisations are struggling with, where staff are refusing to partake in some of the testing. What your thoughts on that were?
Yeah, there's both testing and vaccines they're both difficult issues, of course. I think testing is simpler because it is obviously, by definition, it's less invasive and it has potentially less consequences for people. So I think testing is simpler. I take a fairly robust view, which is that given the nature of what you do, For those people that are likely to come into contact with patients and other significant numbers of staff, which is going to be most of your workforce, I take the view that absolutely, if somebody refuses to take a test in that way, that you can be pretty robust. I think it's a perfectly reasonable management instruction to say you need to take a test. So I think on testing, absolutely, I don't think we should be anything other than robust in that. And if people refuse, and you think that's then going to expose people to harm, I have ultimately, I've got no concerns about taking disciplinary action if people refuse tests. When it comes to vaccine, of course, that's harder because there are people who have good reasons for not taking the vaccine. And I think that makes it much harder for organisations, not just NHS organisations, but organisations generally, to impose that. Because, of course, if you are imposing it upon somebody who's got a disability, or if you're imposing it upon somebody who is pregnant or has a good substantive reason, then I think you do have a problem. But ultimately, you've still got to decide what you do in that situation. And if the only alternative for them is they sit at home and do nothing, or they don't, there's no alternative, you can't put them in an area that's safe, then again, you're back to this very difficult question of what do you do? And I think ultimately you're going to have to dismiss. And I don't think that. I mean, employment lawyers are a bit divided on it, but I think there is general agreement that in this context, given the nature of what you do, either in the care sector or in the health sector, requiring employees to take the vaccine is probably going to be a reasonable management instruction, with the caveat that there'll be people that it's not reasonable to do that for. But then what do you do with them? Because if they're not prepared to take it and you think there is a risk of exposure, where do you put them? So it's a very difficult problem. And I think you're right, Jenny. The difficulty is nobody really wants to go first and tackle this very, very knotty problem. And understandably as well, the voices from the centre have always been very supportive, of course, of staff in this position, and have made it very clear that it won't be mandatory. But I do still think that it's a reasonable management instruction in most cases.
Thank you, Andrew. That's really helpful. I think we're just about out of time. Did you want to say anything else before I try and draw it to a close?
Not for me, no. Just I suppose the only thing I would say is if anybody thinks of any burning questions that they haven't asked, my contact details are on here, and we are circulating the slides. So if anybody does want to get in touch, they're very welcome to. My chargeable clock won't be ticking. You're welcome to ask me a question.
Brilliant. Thank you very much, Andrew. Good session. Thank you to everybody that's joined. And just to trail future webinars, thank you, Heather. So employment contracts and social media uses and misuses coming soon, and we hope more of you join us then. Thanks a lot for your time today. Have a good rest of day and take care. Thanks, Heather. Thanks, Andrew.
Thank you.
Thanks all. Thanks very much.
Bye-bye.
Thank you. Bye-bye.